Hello everybody, this is Jacob Sapochnik, immigration attorney based here in San Diego, California. In this video, we're going to talk about the new changes to the national interest waiver category under the EB2, which is a permanent residency green card petition filing for people that are filing without an employer. It's a self-petition. Now, what is happening right now is that there's been a precedent decision by the AAO, which overturned the previous case that was controlling this category, the New York State Department of Transportation. There was the foundation for the national interest waiver for many, many years, more than 20 years. That's why it's so revolutionary that the new case, the matter of Dhanasar, that, right now we're recording this video in early 2017, January 2017, and this is, it's going to create a whole new foundation for how national interest waivers are going to be filed. And so under the new case, under the Dhanasar case, we have three-prong test that came out. So the first is the applicant must demonstrate that the foreign national proposed endeavor has substantial merit and national importance. Substantial merit and national importance. And again, this is going to be a little bit more easier to show because we can put different elements, whether through a business plan or through the projects, to show how many applicants can meet that standard. The second point is that the applicant is well positioned to advance this endeavor. So whether right now, previously applicants, maybe they needed to hold a degree or really show that they are really, really highly qualified. Now they have to show that they are well positioned, which allows us a much broader options to include in the case, whether they are the project is well advanced, whether they're going to create jobs, whether they're going to be able, their innovation is unique. It's really kind of gives us more flexibility as to what we can show now in those cases. The third prong is that it will be beneficial to the United States to waive a job offer. Again, it gives the USCIS much more discretion as to what they can do to be able to meet that third standard as well, that it will be beneficial to the United States to waive the job offer. So it's definitely less restrictive than before. And I put some notes here, and I actually have the case here. Like previously, the word intrinsic, which is basically required by the USCIS to show, it's a much more difficult standard. And previously, people that filed national interest waiver really had to show that their benefit is national in scope. Right now, they removed the need for locality, to show that the impact is necessarily local. Another thing that I mentioned in the notes is that the court is looking at factors, but not necessarily at the individual's education, knowledge, and skill, but they're looking at other things as well, which is kind of really makes this standard much more open to entrepreneurs. I mean, I'm excited about it because I feel that more and more entrepreneurs could benefit from this, because now the standard is definitely less strict. So it's one thing is that, unlike the previous case, unlike the New York State Department of Transportation, applicants don't need not to show harm to the national interest if a labor certification is not filed. So we don't really have to show that anymore, which was really one of the biggest problems of people trying to qualify for the national interest waiver. It was just very difficult to meet that standard. So right now with the Dhanasar case, we feel that these new three-prong tests are much more wide. They're much more doable to establish, and we are hoping that the USCIS are going to show more reasonableness to applicants that are trying to file for the NIW under the EB2 category. So again, this is all very new. Right now we're in the process of putting together what we believe are going to be the evidence that is needed to be able to meet those three requirements, and we're going to start filing those cases for our clients. I do feel that the standard is much more reasonable, and it will open the door to entrepreneurs, to business people, to scientists, to try to create innovation, to try to do projects and not be afraid that their green card applications will be denied. And so, and of course, the need for an employer that was so restricted before, because nobody could really do anything unless they could able to get an employer to sponsor them, now is going to be much more open for people to try to innovate, create ideas, start companies, and be able to sponsor themselves through the self-petition, meeting those three standards. So hopefully this initial video was a little bit of was informative. Just to summarize, there's a new case, the Dhanasar case, that changes right now the requirements for national interest waiver. The three new standards demonstrate that a foreign national has substantial merit and nationally important, that he is well positioned to advance his endeavor, and it will be beneficial to the United States to waive the job offer. Those are exciting new elements, and we hope that it's going to open the door for more entrepreneurs and innovators to file for permanent residency in the United States. If you have questions or any comments, leave them in the video below, and we'll do more videos as we file more of these cases and get results and let you know what we think of this new and exciting change in national interest waiver. Thanks for watching. This is Jacob here from San Diego, and we'll see you in our next videos.